So the background to all of this, why are we here? Well, OUI and Taylor Vinters and James Preston have been working with very early stage businesses for a long time. And there is a common theme of need to understand what's going on when you're in the process of setting up or running a business at that early stage. And usually at the early stage, you're really focused on the technology you're trying to deliver. And this sort of financial and legal stuff can become a bit of a cumbersome burden sometimes. But if you're not on top of it, then it will actually be a real nightmare. Very often you find yourself expending vast quantities of time trying to either understand or resolve problems that have arisen. So getting off on the right foot, structuring with success in mind, involves having some of this basic information. So this first group of sessions, we are going to be looking at the basic necessity of directorship. And the line between legal and financial is incredibly blurry. So that's why we have a group of us together to address this rather than doing it individually. It's really important to understand who you need to be talking to, because if you get it wrong, it can be incredibly difficult, sometimes impossible to fix. And it's certainly never easy and it's never cheap. So, Nicola, if I could just get your sort of introduction from a legal perspective.
It's really about putting the right foundations in place that enable your company, one, to establish itself, but nobody wants to establish a company and then do nothing. You want it to grow and to scale and to be successful at contributing to the ecosystem, whether that's creating jobs and building teams or whether it's raising further funding in due course. And so a cohort of us sat down and had a bit of a think about all the things that we think that are critical for a company or an organization to understand, either just as the company is growing or maybe when it's maybe even immediately before it's formed. The idea of the program though as well is that sort of people learn from peer groups and learn from each other, and what we really wanted to do is try and sort of create a community of people going through similar things at a similar time, not just people connected with the university but actually people in the wider ecosystem. So entities like Advanced Oxford and STFC, Onion have all been involved in helping us, to bring this program together. And like I said, the idea is very much about kind of creating a community, a peer-to-peer sort of community, as much as, providing you with some sort of legal and sort of financial and commercial training and thought processes. And then sort of going forward, kind of once we've got you all knowledged up, I'm not even sure that's a phrase, but educated, kind of with regard to the basics, our intention then is to sort of move things forward and actually do like an advanced version of this, which might then do deep dives at things like IPOs or exit routes or international strategy, that kind of thing. But we thought initially, let's just kind of deal with the basics and go forward from there. So Sue, I don't know whether you want to sort of talk about how we think it's going to work practically.
Yeah, so practically, we've focused the key issues for this period into 3 clusters, and each cluster will be influenced by a particular sort of broad topic range. Within each cluster, we've got 3 online sessions, which will then culminate in an in-person workshop. And what we do with the workshop is ensure that it is going to be scenario-based. So Nicola and I will come up with a scenario which is based loosely on a number of factual, true circumstances sort of linked together, and that will enable you to solidify the learnings from the online sessions. We're also going to be inviting both investors and mentors to those sessions to give their views on how they would approach particular scenarios and situations. So by attending, you're not just getting our input, but you're also getting it sort of straight from the horse's mouth, if you like, those sorts of people that you would seek to be working with as you spin out or start up and develop your businesses. So, and they'll be giving their time free of charge as well, which I think is a really good opportunity for you to start to build relationships with those sorts of people. And then, and this is the real killer thing, is then at the end of the in-person session workshops, then we'll have some beer, because I think that's also a really good way of building networks and so on, and coming back to the point that Nicola was talking about establishing a peer group amongst you so you can share your learnings and grow together, as it were.
Excellent. I particularly like the beer.
I knew you would do, Kath.
So that leads us to the first question, and it's not who's buying the beer. It's about what is a director, because I know you see director written on business cards of all kinds, but what exactly are we talking about here when we refer to a director?
What we're going to be talking about are those who are statutory directors, and that means that they have the authority and the responsibility to run a company, and that they're registered as being directors of the company at Companies House, which is the UK registry for everything to do with individual companies. And anybody, for example, can search the register at Companies House to find out who is a director of a particular company. When we think about statutory directors, they have authority and responsibility, but it's really important that we also make sure that each company has the right skills across the board of directors, which could well change as the company evolves. And it's not unusual for companies to have a particular blend of directors with skill set at the outset, and then you may only have one or two of them still being with the company 5-10 years later, because the company itself is almost a live being in that it changes and its needs change over time, and as its technology develops, as its commercial market develops, and so on. And another piece that we will be thinking about is that on a board, not only is it about a blend of the right skills, it's also about the right sort of people to help the business to develop. And that's to do with the softer skills, but also is around the whole piece of diversity and inclusion. And there's a lot of evidence to show that more diversity leads to far more successful businesses, because if you've got people coming from different angles and different experiences, whether that's in business, in development of technology, or as people, then you get a lot more sort of dialectic and better results come out of that as a result, much more input to build into more sustainable businesses.
What is a director? You'll commonly hear people referring to themselves or to their board as being made up possibly of executive and non-executive directors. Just to dispel some myths around that. So albeit the executive and non-executive directors might have slightly different roles, they all still owe the same duties to the company. Maybe non-exec directors might have a view or an opinion that they don't owe the same duties, but they absolutely do. There is a difference in role. So your executive directors are very much there to run the company on a day-to-day basis, the operational side of things. You might sometimes hear them referred to as the C-suite. So C-suite is basically any director with chief in front of their title, even chief troublemaker in some organizations, I would suggest. They are there day-to-day operational, running the company, dealing with everything that entails. And then you have non-exec directors. Non-exec directors tend not to be employed by a company. So an executive director tends to have an employment relationship with a company. A non-exec director tends to have an appointment letter. They are part-time. They might be there to come to X number of board meetings per year, maybe some additional time to allow them to prepare sufficiently for those board meetings. The role of a non-exec director I often describe as it's a bit like being a head teacher. You're sort of trying to ensure that everybody's on track and you're holding the board accountable for actually delivering the strategy and the business plan which they have stated that they want to achieve. And non-exec directors also have quite an important role in terms of people like the chair might have some particularly good skill sets at looking at dealing with relationships with shareholders and stakeholders, particularly important as your group of shareholders increases. They might have particularly good industry contacts, or some non-exec directors are there because they're representatives of a stakeholder group. So if you have an investor, by way of example, you might see somebody called an investor director on your board who is there as a representative of the investor. One thing to say, though, is that they might be there as a representative to the investor, they still owe duties to the company. First and foremost thing that they need to do when exercising decision-making in relation to the company is to wear that director's hat first, irrespective of the fact that it might actually conflict with what their position as an investor might be. There is a difference between directors and shareholders. I think that's the other key thing to think about. They might be the same people, but they make different decisions. Directors have duties to the company and have a series of things that they need to think about when making decisions. Shareholders don't. Shareholders can make whatever decision that they feel that they want to make without, reference to any sort of statutory obligation with regard to duties. Duties are owed to the company, which again, sort of sometimes they're not owed to shareholders, they are owed to the company. And therefore that means that the only organisation or entity that can enforce a breach of duties action is the company itself. Sometimes, really, really rarely, shareholders can apply to court to be put into the shoes of the company in order to bring a derivative, what we call a derivative action, which has got nothing to do with financial instruments. It's just a particular name that is given to this course of action where upset shareholders might want to bring an action against directors. An example of this was after the banking crisis, where some of the shareholders from some of the banks that weren't overly happy about the way that things had been conducted applied to court to be put into the shoes of the bank in bringing breach of directors' duties claims. And I think the other thing to sort of note, again, you might often see organisations requesting the ability to put observers onto the board rather than directors. What I would say with observers is kind of the clue is in the name. They are there to observe. They are not there to participate in the meeting. They are not there to vote on decisions. They are there to observe. One thing that people and observers in particular do need to be careful of is that they don't end up being classed as shadow directors of a company. Now, shadow directors has a really sort of technical definition under the Companies Act. But as I say, sort of you just need to be careful that you're not actually being a director without having the title or the registration at sort of Companies House. Because if you do act in that way, then, kind of any court would turn around and say you were ostensibly a de facto director. And hold you to have the same duties and responsibilities that the directors that are registered at Companies House do.
Okay, so you've talked quite a bit, Nicola, about duties. Let's start with you on the duties from that perspective. What are they, and where do we find out what our duties are if we're a director?
What I am going to say here is that we're going to talk about these in a relatively high level today, and we are going to do a much deeper dive into them in the next couple of sessions, because you can go on courses for 2 or 3 days just to learn about directors' duties. I wouldn't necessarily wish it on people, but you can do if you kind of that's your thing. However, what we're going to do is we're going to talk a little bit about what these duties are in a relatively high level, and then next session and the session after, we're going to go much more into the nitty-gritty of, right, okay, you have this duty. Practically, what does that mean? What do you do? And how you go about that. So directors' duties in the UK never used to be written down anywhere. We used to rely on something called common law. And sometimes you'll still hear people referring to acting in the best interest of the company, which was a common law concept. With the 2006 Companies Act, we basically tried to write everything down. And so we now have a list of statutory duties. So if anybody is really, really bored, you can go and look up section 171 to 177 of the Companies Act, and you will find the duties listed there. And they start with things like directors having to act within the authority that they are given, and they go to things like promoting the success of the company for the benefit of the members as a whole. There's non-conflict provisions. Like I say, don't worry about scribbling all of these down, because what we will be doing in the next couple of sessions is going through these in more detail, and also sort of sending you out like a sort of slide with all the directors' duties on. So don't feel that you've got to scribble these things down. However, yes, the Companies Act is one source of what these duties are, together with the factors that you need to consider to determine whether you are successfully discharging them. However, directors' duties can be found in other places as well. I mentioned briefly the duty that you have to act within your authority. The authority in relation to directors can be found in other documents. So by way of example, if you have a shareholders agreement or articles of association, which you most certainly will do if you've taken on board any level of investment, and I would perhaps strongly advocate you have it before that, then you will find provisions in those documents that actually restrict the ability of the company or restrict the ability of the directors to do things unless they have got an additional level of consent. So it might be that actually the directors want to recruit somebody. There might be a provision that says you can't actually recruit a person with that level of salary unless you get the approval of the shareholders, or unless certain directors also, are all in agreement with regards to this decision. Shareholder agreements and articles of association are really important for lots of reasons, but they're also really important for you to know what you can and cannot do, and to recognise that if you try and do something that might be in line with the Companies Act, but actually is not in line with what your shareholders agreement says, you can't ignore your shareholders agreement. And a breach of shareholders agreement, when you go ahead and do something without the requisite consent at a board level, can certainly, lead to a breach of 171, which is this: you must act within the authority that you are given. The other thing to note is that all duties apply to all decisions. And so, again, in the next couple of weeks, we'll be talking about some of the practicalities. And again, it's you can't sort of say, well, we're about to do something that promotes the overall success of the company, but in doing so, we're going outside of our authority. So, you can't kind of pick and choose which duties that apply to any given decision. All duties apply to all decisions. And like I say, we'll be talking through some of the practicalities and what that means for you operating a successful board in the next few sessions. One thing I would say is that you do need to be alive to conflicts as well. So there is a duty to avoid conflict. And again, this gets particularly tasty when you have perhaps investor directors on board, or directors that are, sort of representing sort of different stakeholder groups. Again, we'll be delving into the detail of that, but that's the other thing that I would draw your attention to in respect of being a good director and being alive to your duties. There is that sort of duty to avoid conflict of interest.
And then we come on to the financial duties, don't we? And there are some very specific financial duties that are required of directors. And it's of all the directors. And I think as Nicola said, it's an even-handed approach. Everybody who's a director is as responsible as everybody else for all of those duties. And so if we look at the financial duties, where do they come from and what are they? I think there are probably 3 or 4 different sources of duties sitting under the financial hat for directors. First is as set out in statute. So Companies Act 2006 that Nicola refers to talks about there is a requirement on directors to have sufficient records so that at any one time they know what the profit and loss of the company is, and also that they know the assets and liabilities of the company at any one point in time. So in effect, you can take a snapshot, say yesterday or tomorrow, and you know exactly what things the company owns and what it owes to third parties. You might say, well, that all sounds very straightforward. It's very straightforward when you start off a company because you perhaps don't have very much to actually account for. But as the business becomes more complicated, you have to actually start to think about how you're going to curate that and manage that whole process. And there's software that can help you. There are quite a few regulations around how you have to account. And particularly then we come on to the second level of what you're required to do under the Companies Act. And that's to basically lay in at Companies House every year a record of the company's activities from a financial point of view, called financial statements. And those have to be in a very strict format and in accordance with things that are called accounting standards. So it's not something that you can just necessarily mock up on a piece of paper and submit. It has to be done in a very prescribed way. You also have a responsibility to, under HMRC requirements, to file a corporation tax return every year. If you've got employees, you have a responsibility to account for the payroll appropriately and deduct taxes and national insurance from people's salary before they're paid that. You also have responsibility through HMRC to, if you are an appropriate size, to register for VAT and then to account to HMRC on at least a quarterly basis for VAT that you have charged on to customers, and you sort of net off against that VAT that you yourself have been charged. So that's all encompassed as financial duties from a statutory point of view. You then have duties from a financial perspective to abide by that might be placed upon you by your shareholders and investors. And it's very, very common where we've got third party private equity investors coming in, that you will have within the investor agreement, you will have requirements in terms of provision of financial information to them. Typically, that is every month you have to submit to them monthly accounts, and those may, again, in different investors differ, but some of those actually stipulate the sort of information they require within those reports. So it could be just about your income and expenditure. It could be looking at how you are progressing in terms of your original forecasts. And so that's another layer of duty that you have. You also have overall responsibility. We talked about responsibility to the company. You have responsibilities to ensure that the company is properly run in terms of governance. And that means knowing exactly the position at any one time, which is obviously linked to the statutory requirement I talked about earlier under the Companies Act, but also modelling where you're going to get to, what your forecasts look like, what has changed within the company's commercial environment that might lead it to have to change what it expects the outcome to be, whether it's going to need more funding, when it's going to need more funding, and so on and so forth. There's quite a lot bound up in that. And then the final tranche of source of duties from a financial point of view is those that are placed upon the company and the directors by the regulatory authority. If you're in a particular type of environment, for example, if you were in banking or insurance, if you were an investment company, then you would be required under the regulatory body responsible for that particular area to actually do additional financial reporting to them within particular timescales as well. Another area from a regulatory point of view that is also important to just be aware of is that many technology related businesses or IP rich businesses will seek to exit at some point, and that exit may well be through an initial public offering or a flotation. If you go onto a public market, wherever that market is, whether it's UK, US or Singapore, you will be required by the requirements of that body, that stock exchange, to actually again make financial reports to them, but also to abide by other financial constraints in terms of what information you're allowed to release to a market or make publicly available at particular points in time. Quite a lot all but bound up in that. And what we tend to do as a group, Nicola or myself, you can't do it all at once, but it's a question of knowing what's relevant at each particular point in time. And that's what we tend to talk to people about, that context. One of the other things that it's also important to just sort of throw in at the moment, I think, and I appreciate it's a bit like having a funeral director talking in a maternity home talking about this, because we're talking about insolvency and, if you like, the end of a company as opposed to the beginning of it. When you're starting up a company that's an R&D, largely research and development based in the first few years, and therefore very reliant upon equity funding and not getting revenues perhaps from customers, there is always the prospect that that next round of funding won't come in. And therefore, if that doesn't happen, then you face the prospect that the company might not survive and might become insolvent. If you are in that position, the actual duty of the director turns from being a duty towards the shareholders and or company to actually becoming a duty towards the creditors of the company, so people who are owed money by the company. And it might seem, those two things wouldn't be in conflict, but actually they are, because the shareholders are looking for a return on their investment. Creditors, their interests have to come first and they have to be repaid before anything goes back to shareholders. If you are in an insolvent or a quasi-insolvent position, sort of coming towards insolvency, you can't, for example, pay dividends to your shareholders. You need to be making sure that you can pay all the creditors first of all. But we will come on to that, as Nicola said, probably in a later session. But I think it's just important to just be aware that there are circumstances where your responsibility and your financial duties actually slightly refocus as you're running the company. And that comes back to a point that was made earlier about the fact that, you know, the people who are there on the board of directors will change potentially as the shape of the company changes, and that the company is a very live being, and it itself is changing all the time, and its requirements are changing all the time. Coming back, of course, you know, to financial duties, Nicola talked about the importance of knowing what hat you're wearing at any one time. And that's never more so the case as when you're making financial decisions. The shareholders and the directors may well be the same people. You could be an investor representative, or you could have founded the company and be a director of the company as well, be running the company as well. The different interests of the company and the shareholders may well compete, and you very much have to be aware of which hat you're wearing at any one point in time when you're making a decision. And that's really very true when you're making a financial decision. So just trying to think of an example I can give you of one that I've seen recently, and that would be a company where the finances were tight. There's a shareholder who has said, well, I could take the intellectual property out of the company, and then that's satisfied, you know, then I won't bother about having shareholdings in the company, and then that makes it better for everybody, for the creditors that don't have to think about me. And you know, we had to sort of sit there and explain to them that then meant that the company had no value and no assets with which to pay the creditors, and they hadn't thought their way round that. And the problem was that the shareholders and directors were the same people on the board. So yes, lots to think about, I think. And sorry about being sort of looking on the black side of things as well, but I think it's just as well to be aware of some of these things.
Okay, so you've talked about things going wrong, so I guess that takes me neatly towards asking about the risks that come with being a director and how you can protect both yourself and the company. So I'm going to start with Nicola on that one.
We talk about sort of if you're a director of a limited company, it is quite unusual for there to be any recourse to you sort of beyond sort of the company. And so as in personal risk. So personal risk, you know, comes about either because you've done something that you shouldn't have done in relation to wrongful trading, fraudulent trading, you know, very much on the sort of financial side of things. It could be that corporate veil is pierced because there's been a breach of, for example, health and safety sort of regulations, and there's that sort of reach beyond sort of the corporate entity to personal responsibility and personal exposure on the part of directors in those circumstances. How can you protect yourself? How can you, how do you de-risk being a director of a company? So there are a few things. First of all, a company should, in every instance, have a letter or an engagement document in place between the company and its directors. So whether that's an appointment letter in respect of a non-exec director, whether it's something that we call a service agreement in respect of an executive director. A service agreement is basically an employment agreement that's quite specific for directors. And the reason I say this is because you can use those documents to ensure that it is very, very clear to the people that you are engaging what their role in respect of the company is with regards to governance and duty. So moving on to things like sort of employment and what their employment relationship is something that we'll deal with, kind of in the second cluster when we talk about sort of team and growing a team and the people that are involved with the company. However, any director that is going to be engaged with the company should have a really clear appointment document, which also then sort of should set out the fact that they have these duties and that the company fully expects them to comply with the duties. What a non-exec director appointment letter would also often do is say that in the event that a non-exec, for example, is concerned about compliance with duties, that they're actually able to go and get independent legal advice at the cost of the company, reasonable cost of the company. But like I say, first thing first is from the company's perspective, make sure all of your directors have appointment letters or agreements in place that very clearly stipulate and make them aware that they are going to be subject to the director's duties. You expect them to comply with them, how you expect them to comply with them, and move forward on that basis. The second thing, which is something that those of you who know me will know I harp on quite a lot about, is governance. And by governance, I mean regular board meetings, but also board minutes. Decisions of directors should be made in board meetings. You should have an agenda, you should have regular board meetings. It's a good discipline to get into. It's a really difficult discipline to put in place in 2 or 3 years' time. If you get any level of investment, then investors will absolutely insist on having regular board meetings with an agenda and with the board packs that go with that. First of all, have regular board meetings, but really importantly, is actually having minutes of those meetings. And the reason I harp on about minutes, because people kind of think, oh, well, they're only a few pages long, really, are they that exciting? Are they that important? But yes, they absolutely are. So minutes have a number of functions. One, they provide a corporate memory. Why did we make that decision about that thing 3.5 years ago? It might be that your directors have changed in that time. So it might be, actually, why did the directors 2 years ago make that decision in respect of that thing? What were the things that they thought about? And if you're a director, the board minutes are a way of you being able to protect yourself from a claim in the future. And the way that they do that is by tabling and detailing what discussion took place. Did anybody have a different view as to what we should do in this particular circumstance? What was that view? Why did we go with one view as opposed to a different view? That level of detail, in the event that there is a claim in the future for a breach of director's duties, being able to say, actually, I really didn't agree with this. We were bamboozled by our finance director. I usually pick on finance directors, but we were bamboozled by our finance director. We all thought it was fine. We didn't realise that we were going to be wrongfully trading. Look, I raised questions about it, and I was given these answers, and those answers, sort of proved to have substance or not. I think the other thing to say about board meetings is don't be afraid to question. So if there is something that you don't understand, either in the board pack, or a topic that is being discussed, or you feel that you need more information, do not be afraid to question. And the thing with board minutes is that they should provide an accurate record of the discussions that took place. Sometimes companies don't like the idea that their board minutes might display the fact that there was disagreement amongst the board as to something. And so, sometimes what you see are these sort of relatively anodyne set of board minutes coming out for actually what was quite a fractious board meeting. And they might look nothing like, it literally might be just a couple of lines about something that, you argued about for an hour and a half. From a personal perspective, I would be, in the first instance, going back to the person who took the minutes and saying, by the way, here are all these things that were brought up and that don't appear to be in your minutes. Please, can you include them? Is step one. Step two is if they decide they are not going to include them because they want everything to look as if it's a beautifully harmonious company where nobody falls out with each other, you can actually have a second set of board minutes. So you don't have to have just one set of board minutes for a board meeting. You can have 2 sets of minutes for a board meeting that actually reflect the difference in content that perhaps people perceived. We came across it you hope that people don't fall out with each other too often, but we came across it in a situation very specifically with regard to directors' duties, where a French private equity fund had bought 51% of a UK company. And there was an option for the private equity fund to buy the remaining 49% of the company from the original founders based on a formula. And that formula was linked to the future performance of the company, the future revenues of the company. Having bought the company, it just sat there. the English directors or the English founders were going, actually, we've just found this great piece of IP that we'd really like to do something with, or we've just found this commercial opportunity to do something with. And the French private equity fund were going, yeah, no. It transpired that ostensibly the French private equity fund had bought this company as a defence strategy. So they'd bought it entirely with the purpose of putting the IP on a shelf and never being used. So the two guys who had founded the company basically were never going to see anything in addition to what they'd already sold their 51% with, because they were never going to achieve the revenues that meant that they got an optimal performance out of the formula. And the reason I say that board minutes were important in this circumstance is that we acted for sort of the two UK founders when they came to us and said, this isn't working, what can we do? And it came down to directors' duties and conflicts of interest. And what it transpired was that the IP that these guys had created was to do with financial security. They had been put on notice that some really large financial institutions in the US were ostensibly infringing their IP. And they had as robust opinion as you could possibly get out of a US IP attorney to say this is a dead cert case and you'll get gazillions in compensation. So they went to the French directors and they said, right, okay, kind of our IP is being infringed. We really need to be doing something about it. And the French directors said, no. And there was a big board meeting and it transpired that, and we raised all of these things at a board meeting, and both sets of lawyers turned up to this meeting in Paris. Both sets of lawyers were sent to the corridor outside the meeting. Both sets of directors had walked in with pre-drafted board minutes from their respective lawyers. We sort of, pushed the point, why was it that they weren't prepared to defend the IP? And it transpires the people who were infringing the IP in the US happened to be really big clients of the French private equity fund. They didn't want to sue them because they didn't want to upset the relationship further up their structure. And it was a complete conflict of interest. It ended up settling literally on the steps of court. They'd gone through, sort of mediation, and they went to court. And we ended up with a settlement that actually meant that they bought our guys out of the company 2 years earlier than they should have done, at a sum that was then agreed. But like I say, sort of it was that director duty point. It was a really clear conflict of interest. It was very clear they weren't acting in the overall for the overall success of the company. And board minutes were absolutely critical in helping to substantiate that claim. So board minutes, really important. I do go on about them quite a lot, but that's because they are really important. They might be drafted by, kind of junior members of my team, but actually they are fundamentally important in terms of corporate memory and in terms of giving you a defence to any action that you might have taken. So Sue, over to you and your thoughts.
Yeah, I think it's really important that you're aware, if you're a director, you're aware of the decision-making process that the company needs to go through. And that might sound very obvious because surely you just sit around a table and agree things or not, as Nicola's just alluded to. Sometimes you also will have, if you've got investors, you'll have requirements within the investor and shareholder agreements and the articles about consents that are needed before you can enact things. So, for example, you might not be able to take a decision about a disposal of a certain proportion of the company or certain assets of the company without having the explicit consent of key shareholders. So it's not necessarily, therefore, decision making on a basis of one vote per person, or alternatively, votes on the proportion of shares that you actually own in the company. It might be that there is a veto there or an explicit consent required from particular shareholders. And I think it's really important, and from my experience of sitting on boards, and I sit on a number of different boards and have done over a number of years, the earlier you engage and involve different stakeholders in relation to key decisions, the more likely you are to avoid or mitigate any issues. The worst thing is when you blindside somebody at a board meeting by introducing a major issue that you've perhaps gone quite a long way down the track in terms of deciding, and you expect them just to sort of sign off on it, and they might sort of feel they should have known about it a bit before, they should have had more information. And if you engage with people and ask them to get involved in the decision making, it's much easier. And I saw this recently in relation to a company that I was called in to advise, and they'd been promised a deal with another company. It was a big corporate, very exciting name, to get involved, and literally the paperwork was on the table to be signed off by our company and the other side, and the investing sort of potential customer. Other side, sort of front person, if you like, had forgotten to actually involve their CEO. The CEO just sort of turned around and said, well, actually, I'm not at all interested in investing or being involved in an early stage technology business. Not having had that discussion early on meant that a lot of time was wasted, but also from the perspective of our client was that they themselves had wasted time because they thought that they'd got this white knight coming over the hill on a horse, to go and save the business. And of course, that wasn't going to happen at all, but they'd not then looked at other alternatives. So I think, it's really, really important to engage with everybody around the board, particularly those people that need to give you formal consent. When you are a director, it's important that you ensure that you get out board packs well in advance to the board of directors. So that would be, all the papers that you're going to talk about, that you give people sufficient time to understand the board packs, and that you as a director have the responsibility to read through the board pack. There is nothing worse in a board meeting, I think, than somebody presenting a paper and having to go through it line by line because the rest of the directors haven't actually sat there and read through the paperwork beforehand. So you're not able to have an informed discussion, which is what you should do. You shouldn't be reading through the papers, you should be talking about them. If you need clarification from professionals on key issues or risks such as the financials, something technical, or indeed a market, from a market point of view, then you should bring that into the board in the paperwork that they get before the board meeting, so that the debate that you have at the board is a really informed one, and genuinely look at the risks and the upsides of any decision-making strategy that you're considering. Now, we've talked a lot about risks for directors. We've talked a lot about responsibilities and duties. There are things that you can do to mitigate the risks that you as an individual director have. Talked about making sure that you get information, requesting information. There is another thing that you should do, every director should do, and that's to have the company take out on your behalf director and officer insurance. Now, that doesn't absolve you from negligence, but if there are issues that come about within the company, then you can be insured against some of the risks that you run from the corporate side as well. And that it's definitely very important to take that out, that the company takes that out on your behalf, and you ensure that has happened. So I hope it hasn't sounded too doom and gloom, but actually, this is a really exciting time to be, setting up a business is really exciting, and being a director is exciting, but it's only exciting if you understand all the issues that you need to cover, because what we're hoping to do is to enlighten you around those, and not, so then you're not tripping over things later on thinking, oh my goodness, what am I going to do about that, but that you can actually focus on being a director in the proper way.
Excellent. Well, thank you both very much. We have got a few questions, so I'm going to start at the top of the list and work my way down. Excuse me. I think you've partially answered the first one. But Sandra asks, what's the best practice regarding board packs, and how much in advance should these be sent, and what should be their content? Now, I'm just going to put in here a little personal view. All of the individuals on a board will have a lot of other things to do. So I would answer that question by considering how much in advance you would want to receive that information if you were in their shoes. So, for example, the boards I'm on, if I get stuff less than a week ahead, the chances of it being read, digested, revisited with a little bit of hindsight I've had a chance to think about that and just ask a few questions. If it's less than a week, I'm simply not going to be able to do it. And that's the reality for the majority of people who are on boards. I sit on a board well outside work where the requirement is 2 weeks because everybody is in full-time paid jobs elsewhere. So those are the considerations. Are there any other thoughts from Sue, Nicola, on that particular one?
So I agree with that you basically, you're not going to be able to comply with your director's duties unless you've been able to, read and digest the information that are going to help you make an informed decision about something. In terms of content of board packs, quite often, particularly if you've taken on board investment, that's actually dictated to a large extent by your shareholders agreement. So there will be a requirement, for board packs to include, for example, financial updates, maybe record of how you're doing against business plan, that kind of thing. And it really is, again, you will also have in your shareholders agreement provisions that say you can't do this without the consent of, whoever it is at the board or without it being discussed at the board. So again, go back to your shareholders agreement. If there's anything that you are anticipating having to do, significant capital expenditure, recruitment, those sorts of things, big joint ventures, anything like that, then that should be tabled at a board meeting to enable a full discussion to take place. And also in terms of the board packs, the other thing, and again, I'm very conscious that I'm saying next time we'll do, but one of the things that we will drill down to when we go into some of the specifics of the duties is that there are going to be things which actually may require you to take specialist legal advice as a board. Even legal, just specialist professional advice, there might be a regulatory issue, there might be an environmental issue, there might be, 101 other things that come up where actually you need to go, take advice from, the respective, professional, again, in order to enable you to make an informed decision and be able to point to the fact that you made that informed decision because you took the right advice at the right time. I think that would be, my view, circulate it so that you've got enough time for everybody to read it. Quite often that's dictated by your shareholders agreement with regard to a minimum period anyway. I would expect 10 business days. I would feel is about right. If you've got anything on the agenda that requires any degree of specialist input beyond the skill set of the people on the board, then go and get the appropriate advice if needed. Look to your shareholders agreement to see whether you're about to make a decision on something that requires a specific level of consent, and again, table that accordingly.
Sorry, I would just add to that, if I may. People think in different ways and people need to absorb information in different ways. A lot of research around that. And hopefully around your board table, you will have people who are a blend of those that like to just look at a higher level of information and those who really want to drill down into detail. And so it's important, I think, when you send out board packs that you have that in mind. So what I tend to do, and I'm sending out stuff myself, is to have for each paper to have a summary sheet or a dashboard at the front, which gives people the basic information, summarize what decision you want the board to be making in relation, as in what they need to think about or what they need to be considering, and then have a lot of detailed paperwork behind for those that want to drill into that more detailed information. I think it's quite a useful thing to be thinking of.
And I think for those of you who are going to go on and be directors and might not necessarily be the person sending out the board pack, implicit in the receipt of a board pack is your need to read it. If as a director you turn up unprepared to the board, having not read it, I would say that you were heading towards some kind of disaster, because that's arguably bordering in the direction of negligence, because you've neglected your duty to inform yourself on the things that you're going to make decisions on. So, yeah, it works every way. Send it out well enough in advance for people to be able to do so. And if it's sent to you, read it and ask questions if you're not clear, because you're probably not the only one thinking that particular question. You talked about having duplicate sets or multiple sets of board minutes where there's been a little bit of discontent in the camp. If there are two sets, Rachel asks, how do you know which one is a true account of what happened? Now, that's a good question.
It is. So What you end up doing is you might actually end up with 3 sets of board minutes. So what you will have is probably a relatively anodyne set of minutes, which of non-contentious points. This was tabled, we discussed it, this was the outcome this was the decision that was made because, whatever the weight of the votes was at the board meeting. That shouldn't be contentious between anybody. In the event that then discussions where people had different opinions and they want those different opinions recorded, then that is where you then have your different sets of minutes with, well, actually, I said all of this and you said this, and, kind of you haven't put that forward, and then somebody else responds to that or puts in, it's just something at the sort of same time. The only thing that you can know that is true record of the things that are in just using the board minutes are the relatively, anodyne minutes of this was tabled, this was discussed, this was the outcome of, this was the decision that was made. And then with regards to sort of the other sets of, the sort of duplicate sets, they are very useful as a contemporaneous, this was our view, this is what we advocated, this is what our concerns were, record of thought at the time. And then in the event you ever had to use them, in anger, and I strongly hope that none of you do, but in the event that you had to use them in anger, it then forms part of an overall sort of evidential trail of how people have behaved, or kind of what your particular stance on a matter is when you're trying to enforce something like a conflict of interest issue. Like I say, that's how it works. It's not necessarily entirely binary, but what it is, any board minutes are just really useful sort of corporate memory things. And actually from your own personal perspective, if you know that you have put something forward, you can quite easily demonstrate it. Also, if you've sent, emails beforehand in response to the board pack, by way of example, then that's what but if you're getting into the situation where you have multiple board minutes, then I suspect you might have 1 or 2 law firms involved with litigators involved, because if you've got to that stage, that is a contentious situation, then I suspect people should be taking their own legal advice, and it then goes into the hands of my really nice colleagues, the litigators. But I would hope that you never have, they're really nice, but I would hope that you never have to get to them because they're really expensive. You're better off doing things, sort of right from the outset rather than ending up in front of them.
And I have actually seen a very well done set of minutes where there was huge contention in the board. I mean, it did almost end in blood. But what happened was the minute said there was a robust discussion around the following, and they used the word robust, discussion around the following topic. A presented this opinion, B presented that opinion, C presented that opinion. We took a vote and the decision of the board was. So everybody has had their decision recorded. However, they have not ended up with 3 or 4 sets of minutes.
And this is also where a really good chair comes into the fore as well. You have very rose-tinted glasses if you think that you're going to go into this and never have a difference of opinion from your fellow directors. But that is going to be the case at some point during the life of the company. And actually, debate is healthy, and other people's opinions are healthy with regards to what you're doing. And you shouldn't be afraid of expressing that opinion or indeed getting it recorded, and nobody should have a problem with you doing that either, because I'm sure they want their opinion recorded as well. And yes, in hopefully the sort of grown-up world, those sets of board minutes where you have different opinions expressed and recorded is absolutely what I would strongly advocate would be the case.
So Serena, we may need you to clarify what you mean here. If a conflict of interest is known but not declared, can this be documented somewhere for record of corporate memory?
So most companies, as a matter of good governance, will have a register of conflicts, so that when you are appointing directors, and let's just say they're involved with other companies by way of example, you know that up front, if they're a shareholder in another company, if they're a director of another company. So any good governance of a company should actually have a register of conflicts anyway, just as a matter of course. If there is then a conflict that arises that perhaps hadn't been foreseen, you can ratify board decisions. So, okay, the conflict is now I absolutely don't think this is what, but I'm just saying you should declare the conflict when the conflict arises. In the event that somehow somebody just forgets to declare a conflict, then you can ratify board decisions if needs be by going back and saying, right, we now know there's a conflict, but actually we would have still decided the same thing had we known that conflict. But like I say, it's not something I would particularly advocate as a good way forward. One of the things that we will look to do as we move through the programme, and particularly when we get to the end of the workshop, there are some relatively pro forma board minutes that you can use as a framework for any board meeting, and they will include as an agenda item any declaration of a conflict of interest, because it should actually just be one, are we quorate? Two, who's got a conflict? It should almost be the first two things on a board agenda. And so, by the time we get to the end of the practical side of things, we'll be able to let you have at least a pro forma framework that also should hopefully avoid that ever coming up as an issue for a company.
Yeah, and that was the correct interpretation. Serena has approved your response. David, what rights do holders of options have?
None.
Well, yeah.
they have a right to exercise those options when the vesting conditions are met. And so they're a bit like some phantom, it's a promise of shares in the future, and it's a promise of shares in the future that will vest when you've met the conditions attached to them and will turn into real shares once you've paid for them. And then having paid for the real shares, those shares will then have the rights attached to the shares that are set out in the Articles of Association.
So James asked, does the list of directors held with Companies House always reflect the makeup of the board? For example, if a company is founded with 3 founders as directors and only one founder ultimately is on the board, do the other founders resign their directorship?
Theoretically, Companies House and the register should always reflect who the actual directors are at any one point in time. I say theoretically because sometimes companies forget to file the updates to the register, which is illegal, and potentially criminal action can ensue as a result. Yes, it should reflect who it is. So typically, I think the scenario that David's probably talking about is where you start off with 3 founder directors. Then as you take investment in, the requirement of the investor is that the board changes and that you perhaps just have one of the founders remains the director. So in those circumstances, then yes, the other ones would resign their directorships, and that would then be reflected at Companies House, and that would be very much part of all the paperwork that goes around the investment round. What I have seen in the past, I don't know if Nicola's seen this as well, are circumstances where perhaps you've got 3 founder directors, the investor comes in, only wants 1 founder on the board, which is all agreed, is that perhaps, a year in, then one of the other founders cycles in to be the founder director representative, and the other one resigns. So that does happen occasionally, and it can be effective. Or there are also, and I've been in another scenario where the non-director of the founders then has observer rights to come to the meeting. That's just agreed at the board that he can come in, or he or she can come in, or that they can substitute for each other in terms of decision making at the board. But personally, it's much cleaner for everybody, bearing in mind all the responsibilities we talked about, if you just have the one person who is the director actually doing the director role.
So I would agree with that. So the statutory register, as is already said, the statutory register both at Companies House and indeed in your company books, and actually your company books are the absolute record of what the position in the company is versus Companies House. In the event that you have the scenario where you might have 3 founder directors, let's just say, to start off with, and then your investor comes along and says, actually, we don't want all 3 of you representing the founder group, you can have 1 founder director, and you decide who that 1 founder director is going to be between you. There are different ways and different reasons why people are on boards. And so if you've got 3 founders, and actually what you have are 3 founders doing 3 different roles on the board, so you might have let's say you've got a CEO, COO, and a CTO amongst the sort of three founders. And those are the responsibilities that those founders are discharging. If an investor comes along and says, actually, I only want one of you to be what we call the founder director, doesn't necessarily mean to say that the other two lose their position on the board. You wear different hats. So as a founder director, which is a right given to the founders under the Articles of Association to have a director representing them as a group of founders with their shareholding founder hats on, that is one role. It doesn't necessarily prevent you, however. You might have the one person who speaks for the founders, but it doesn't mean to say that the other two wouldn't remain on the board, because they can remain on the board as executive directors. They just are, who have a role, like an employment role with the company and a responsibility to the company. But it just means they aren't there as the sort of stakeholder representative of the founding group. So there are different ways that you can be on a board, either because you're representing, for example, a stakeholding group like the founders or the investors or the university or whoever it might be, or you can be on the board because you've been appointed to the board because you're useful. So, kind of your non-exec directors, your sort of C-suite directors, etc. So either way, the registers and Companies House should be aligned and should be accurate. But like I say, just following through, just if you do have, an investor coming along saying we only want one founder director, it might be that they're talking about a director who sits there as a representative of that stakeholding group, rather than the directors who are in the company who might be founders but actually have executive day-to-day roles in the company.
Excellent. So I've got one final question, which I think you'll find fairly easy to deal with. Without a shareholder agreement, what is the default enforcement? Companies House details?
What is the default enforcement for what would be my question for that. But in respect of it's actually your company books. So your company books are the go-to for who owns what in the company, for who are the directors, for who are the shareholders. And that is, absolutely, kind of the golden, sort of go-to record of anything to do with the company. And Companies House should then reflect what is in the company registers. By way of example, with regard to who are the shareholders in the company, if somebody has transferred shares halfway through the year, that change in share ownership will be recorded in the company books. It won't necessarily be recorded at Companies House yet, because you won't have necessarily had to file a confirmation statement which sets out who owns what in the company on an annual basis. So the absolute default and like I say, sort of fundamental, which is why lawyers get very excited about them, is the company books. When I was a mere trainee, sort of company books were actually books, and you did used to have to go and, read somebody's really bad, sort of fountain pen writing somewhere. Or as a trainee, the responsibility of writing up the books was huge. I can tell you now, you used to write it in pencil and then write over it in pen just to make sure you didn't, get it wrong. They're all electronic now, so no need to read anybody's bad handwriting anymore.
Okay, so that's brought us to the end of our questions, and indeed to the end of our time. So what happens next?
So what happens next is we're dragging you all back on the 11th of May. For those of you who are incubator companies and were concerned that there might be a conflict in your diary on the 11th of May, the conflict has now gone. The conflict was this very lovely lady here, and she's unconflicted herself. So your diary should now be, like I say, sort of freed up to come and join us on the 11th of May. And like I say, sort of that is where we really will start delving into some of the details of these duties and what each duty means on a practical basis, and also starting to look at things like shareholder agreements, articles of association. Just, in terms of what we intend to cover over the next couple of sessions, it is things like, obviously, directors' duties, but things like shareholders' agreement, articles of association, your cap table, different types of funding that might be available to the company, valuation and what that actually looks like, and sort of an introduction to concepts such as EIS and SEIS when we're talking about sort of funding as well. So it isn't just going to be about you're a director and here are all these awful things that you've got to comply with now. It's kind of much wider around actually sort of setting up the right foundations for the company from a governance perspective, so that kind of you move forward onto that next step with the best possible sort of foundation blocks that you've got.
So today was the warm-up. We've given you all the bad news. It gets better from here. We'll give you all of the good things that you can do once you've got a company and you are a director, and give you all the guidance to keep you nice and safe. The 11th of May, just to follow on from what Nicola said, so if you're an incubator company and you're expecting to do a session on finance on that day, it has not yet moved in your diary, but it will be moving. So bear with and we'll get that all sorted out. Do not panic. It will all be fine. So any parting words from you, Sue, and then we can wrap up.
The only thing I would say is to reiterate that actually running a company is great fun. It's a great adventure. You never know where it's going to take you, but you get lots of experience out of it. And, what we're hoping to do through these sessions is to give you a few tools that helps you get the good stuff rather than have to deal with the rubbish stuff.
Very nice to see Sam Conway on the call here, nodding and smiling at the fact that running a company is fun, because you've been through a few on the way past, haven't you, Sam? So
yeah, absolutely, and it really is. And I think the great part about what I'm hearing, unfortunately, I was a little bit late, but the great part about what I'm hearing is it's all incredibly useful, and you need to know it, because it's very easy to get caught out. It can be overwhelming running a company. But the big thing is, work through the course, work through everything that you're going to do here and take it on board. And, I've done these things before, but I try and do them all the time, because you never know what snippet of information you're going to pick up, you're going to have presented in a different way that you'll understand better, that will reflect in how you run a company.
Thank you, Sam. Right, thank you, Nicola. Thank you, Sue. Thank you, everybody, for joining us. So 2 weeks' time, the 11th of May. And if anybody has had any problems with comms or whatever, please let us know, and we will deal with anything behind the scenes to make it even better for next time.